the art of drafting plaint, petition, sequences and balance. Object of plaint and petition, if we remember that, if we look at the object, I think we will be able to find out what is the way forward for all of us. What is the object of a plaint and a petition? First of all, it is to ensure that the judge who reads it, who will deal with the matter, is able to understand the case, the factual matrix of the petitioner or the plaintiff without any hassle, without being required to go back and forth. Secondly, and I'll revert back to this first object a little later. Secondly, it is to enable the opponent to know what your case is, the factual matrix. And thirdly, equally important, is to enable the lawyer, when he starts a cross-examination or when he starts the final arguments, to know what the case is, what the factual matrix is, without any difficulty. In fact, many of the youngsters who will prepare the plaint, by the time the matter comes up for final hearing, they would have become seniors. They would have forgotten the facts. Somebody else would have cross-examined, and the pleadings, they must be able to understand without much difficulty. Now, as far as that is the reason why one of the first things that a lawyer must do is he must write the plaint or the petition in a simple language. We must remember that we are not writing a Shakespearean drama. We are writing a petition, a plaint, with the object of ensuring that any person who does not have much of a time is able to comprehend what is written there in the shortest possible time. Let us remember that there are 2 crore cases pending all across India. In each court, nearly 100 cases get listed. That judge will not have time on hand to peruse through a document or a plaint which can run into 50 or 100 pages. It is for this reason that one must cultivate the art of précis writing. I am told that nowadays in the high school you don't have Wren and Martin grammar. When we were young, when we went to high school, we had what is known as Wren and Martin grammar, English book, English grammar book. We were given essay running into about 4 or 5 pages, and we were asked to encapsulate the whole thing into 2 paragraphs. Entire idea that was contained in 5 or 6 pages should be encapsulated in just 2 paragraphs. Brevity is the soul of wit. If we remember that, we will be able to do this effectively. Art of précis writing, ability to write and put things in the most simple manner, in the most concise manner, using simple language, not very high-flying words, and as far as possible, make it as short as possible, but encapsulating everything that is required to be stated. One of the first things that a lawyer must do before writing a plaint or a petition is know the law. Just today, one of my colleagues, and he's sitting here, he prepared a plaint. What is the plaint? The neighbor has constructed a building without leaving setbacks. We all know that in every planning authority has building regulations. Every planning authority has what is known as zoning regulations. Courts have time and again held that zoning regulations are statutory in character. My colleague prepared a plaint without even looking into the zoning regulations, without even knowing what it is. Therefore, first thing that a lawyer must do is, when a client comes, try to find out what the law is. You will be in a better position to write the draft the plaint or the petition if you know what the law is. Let me give you one illustration. In the old Specific Relief Act, prior to its amendment in 2018, Section 16C said that you must ever and prove that the plaintiff is ready and willing to perform his part of the obligation. And the courts have time and again held that if you do not ever and plead that the plaintiff is ready and willing to perform his part of the obligation, the plaint is liable to be rejected. Fortunately, in 2018, there is an amendment to the Specific Relief Act, and Section 16C has been amended. What I am saying is, if you know the law, you will be in a better position to draft the plaint. You will be in a better position to encapsulate what are the salient features of legal issues and modify the facts to suit the law. I'm not saying tweak the facts. The facts are known to you. Let me give you the same illustration of my colleague drafting the plaint. There is a judgment of the Karnataka High Court which held that a neighbor has no right to file a case saying that the setbacks have been violated by the neighbor. But he can do so if he pleads that, or if he is able to prove that the neighbor's action in not leaving the setback affects your right. Had my colleague known this law, he would have mentioned the salient features of in the plaint that as a result of setback not being left, the plaintiff's right to light and air is adversely affected. He did not mention it. Had he known the law, he would have stated so. Therefore, friends, always, as far as possible, try to know what the law is in relation to the subject matter of the case, which is in respect of which you are either drafting a plaint or drafting a petition. Let me give you one more illustration. Many of you who are practicing in the High Court file a petition for quashing the complaint under Section 482 CRPC, Criminal Procedure Code. Many of the statutes, like the Negotiable Instruments Act, which all of you are familiar with. In the Negotiable Instruments Act, Section 138 to 142 specifies that if a company is the issuer of the check which got bounced or which got dishonored, the directors or the officers or the company who are in charge of the day-to-day business of the company are also liable. The law is that if the company is not made a party or as an accused, the Supreme Court has held that the entire complaint is liable to be quashed. If you know the law, you will correctly make the company as a party, as an accused, along with the directors. You will also allege that these persons are in charge of and responsible for the carrying on of the day-to-day business activities of the company. If you do not make that averment, a 482 will be filed and the complaint will be liable to be quashed. Therefore, know the law. as far as possible. Yes, many a times we may not have the time. There is an urgency, an injunction is needed. You may have to draft it out. But if you have the time, if the client can wait for a day or two, look up the case law, look up the law, then you will be in a better position to draft out the plaint or the petition. Similarly, when you prepare a plaint, please add, many a times, what we are required to do is, we may have to set out in a petition, say in a writ petition, we may have to set out we may have to refer to certain sections, certain rules. If possible, please call out the section or the rule in the plaint or the petition verbatim. Reason is simple. The judge many a times may not have the book. Even if he has a book, if you refer to some 3-4 different sections of different statutes, he may not have the patience to look at, take out 3-4 books. If your petition has all those statutory provisions or the sections culled out, it becomes easy for him. Now, coming back to the plaint, please look at Order 6 and Rule 7 of CP Code, Civil Procedure Code. It specifies that plaint must contain material facts and facts alone, not the law. There's a world of difference between a plaint that you prepare in a suit and a writ petition that you file before the High Court, which you file under Article 226 or 227 of the Constitution of India. When you file a plaint in a suit, you have to only plead facts, the material facts, not the law, not the evidence. But when you file a petition under Article 226 or 227, a writ petition, you are required not only to state the facts, but also set out the law and also the evidence. If you can just make a note of 2 judgments of the Honorable Supreme Court of India, where this question was gone into by the Supreme Court. 1988, Volume 4 SCC 534, Supreme Court has held that in a writ petition, evidence regarding facts must be pleaded, and the Supreme Court further goes on to state that is, evidence regarding facts being pleaded in the writ petition is the difference in pleading in a writ petition and civil proceedings under the Code of Civil Procedure. In fact, in 2012, 12 Supreme Court cases, page 63, paragraph 20, Supreme Court has held that the grounds not taken in the writ petition but raised only in the arguments, grant of relief is bad. So that is the difference. When you file a plaint, as I said, let me give you the way forward. First, try to know the law. Second, draft out a plaint using simple language, short sentences, not too long. Use active sentences, not passive. If somebody has beaten you, say that he has beaten you. Instead of saying, I went there, the man came from behind, he had no other business, he tried to beat me, and ultimately his hand hit my face. This is not the way to put forward. Put the thing straight. You must hit the head, nail on its head. As I said, judges don't have time. Time is not a luxury that our judges have. with hundreds and thousands of cases in their court hall, they would be happy when you can prepare a plaint which runs into 4 or 5 pages instead of making it a 100-page plaint. If you can make it shorter, they will also appreciate it. Always use simple language. Let me repeat myself. We are not drafting, or we are not trying to recreate a drama, a Shakespearean drama. It's not a magnum opus, as they say. It's a simple plaint that the judge must be able to appreciate. The facts must be stated succinctly in a chronological manner. Always put different ideas in different paragraphs. I've seen one paragraph running into 4 pages, 5 pages in a plaint. Please don't do that. Let your ideas get shortened, bifurcated. Each idea in a different paragraph, using simple sentences, short sentences, and as far as possible, as concisely as possible. That is the beauty of drafting. That is what you must learn. More than anything else, after you draft, please read it, correct it, edit it. When 2 different clients come to your office, one with tattered clothes, another with, neatly dressed attire, normal human inclination is to call that other person who's neatly dressed. Please remember this. The judge will appreciate you better if your plaint is concise, precise, and to the point. If it is well drafted, grammar mistakes, spelling mistakes are extremely common. Let us avoid it. After all, the judge, if you have drafted a plaint with the spelling mistakes, grammar mistakes, what kind of a respect will he have for me if my plaint has innumerable spelling mistakes? So please remember this. I have always said this. Management techniques must always be adopted and evolved, adopted into our practice and profession. What is this management principles? Your attire, your writing, your drafting, time management, all these are part of management techniques. Therefore, the petition or the plaint must, as I said, be organized. It must be short. It must be sweet. It must be concise. Then there are also other facets. What are they? You are filing a suit, seeking an injunction, restraining a person, your neighbor, who's trying to interfere with the construction that you are putting up. Many a times, we start describing, saying that, I built a building, it is under construction, going on, there is an interference. Simple thing is append or annex the photograph of the building. If the building has come up to some 2 floors, the building is of 4 floors plan, any judge worth his salt will say, let the building be completed. Because otherwise, it will be not only a waste to the plaintiff, but also to the nation. It will be a national waste. Normal inclination is when half constructed building is there, they will say, please let him complete it without pleading equity. So please, if possible, produce a photograph. Documents. Original documents must be produced. All of us know about it. As far as possible, documents in your favor, please append it. When you go to a court, argue a matter for admission. After all, in a plaint, you don't have admission, but you may be going there to argue an application for injunction, temporary injunction. If possible, prepare a short synopsis, 1 page or 1.5 pages. Set out the facts in a chronological manner. Set out the salient features of your case in virtually like a half sentence. These are the techniques that you must evolve and adopt. That is when you will become successful lawyers. Let me now come back to the High Court practice or an appeal against a conviction. Before the Sessions Court, you will file an appeal. When you file the appeal, either before the Sessions Court or in a 482 petition to quash the complaint, what I have invariably noticed is lawyer will set out the entire complaint, the hoary details of how this gentleman with his sickle, he hacked somebody, or that he cheated the defendant or the complainant of thousands and lakhs of rupees. If you put that in the beginning, when the judge reads it, he will have enough prejudice against you. So what is it that you do? In the beginning, try to set out what your case is, how you are innocent. Thereafter, if necessary, put all these hoary details of the complaint. After all, in a cheating case, you want to file a 482 petition. Let me give you one illustration. The complaint filed before the police is, or the magistrate is, that the person has taken 10 lakhs of rupees with the promise to return it within a month or say within 2 months. He did not return it. At the time he borrowed the money, he did not have intention to return it, therefore cheating for 420, 415, 420. That is the complaint. When you file a 482 petition, if you start, narrating the complaint itself, when the judge reads, he will not have any sympathy for you. On the contrary, if the facts are that this 10 lakhs that was paid by you was return of the amount that, he has paid the money to you. His case is that you are not returned. If your case is that he was returning the loan that he had borrowed from you, put it first. Instead of narrating the entire complaint in the beginning and at the end saying that he had borrowed the money from me, therefore he was returning this. Always think, this profession of ours, I always say this, is a thinking profession. Think 100 times. I think I did mention this somewhere in one of my speeches. One of the juniors of Sri Parasaran, who was one of the really great lawyers that India had, who was Attorney General of India, he said, Sri Parasaran has 50 different constitutional books, bare acts. And each time a particular article comes, he takes a fresh book. He reads that section or the article. After all, in Constitution, it is the articles. Every time he reads afresh, he gets a better idea, a better insight, a newer nuance. That is what is needed. Think always. When you prepare a draft, a plaint, think how you can improve. Lawyer must always remember this. Adopt, evolve, improve. You must always achieve towards perfection. That is when judges will eat out of your hands. When the judge comes to know that you are meticulous in your preparation, he will listen to you more carefully, with greater attention than when he gets an impression that you are callous in your work. That is why my earnest endeavor to every lawyer in the profession is think. When you draft, think. After drafting, think. After the first draft or the second draft, think how you can improve. You will definitely improve. That is why I said improvisation, trying to evolve, trying to better your earlier draft. That will yield great results to you, for you in future. Now, coming to the drafting of the appeals. After all, what are appeals? Appeals, in so far as civil courts are concerned, are the continuation of the suit. But before I come to the appeals, let me remind all of you that we have today the Commercial Courts Act. In the Commercial Courts Act, different provisions are set out. In the Commercial Courts Act, Order 13, capital A, Rule 3 and Rule 4 are important sections or orders which have a slight deviation from the Civil Procedure Code. Today, earlier the statutory bar was 1 crore rupees for a commercial suit. Today, it is reduced to 3 lakhs. Any commercial dispute of 3 lakhs is a commercial dispute, and therefore the Commercial Courts Act will apply. Under Order 13, capital A, Rule 3 and 4, it specifies that the court may give a summary judgment against a plaintiff or the defendant on a claim if it considers that the plaintiff has no real prospect of succeeding on the claim, or the defendant has no real prospect of successfully defending the claim. So these are the things that you must remember, read. Library should be your best friend, your second home. That is when you will be a better lawyer. Read, improve, improvise. Similarly, you have Order 6, Rule 3A. In fact, you may remember that if you do not file the written statement within 120 days in a commercial suit, you lose your right to file the written statement. That is why I said one must know the law. One must know the statutes. Lawyers' work is 24/7, not 10 to 5. It is 24 hours. In fact, I did mention this on an earlier occasion to you. I went to take my second vaccine today, just now at 4 o'clock. Looking at me, the doctor immediately asked me to come in. There are instances where, I took an appointment earlier, so I went. Similarly, the doctor you would want the doctor to treat you in the best manner possible. When he injected me, I didn't want any pain. As a lawyer, your attempt should be to give succor to the client. When you go to a doctor, you would want him to treat you in the best possible manner. When he injected me, I didn't want him to, cause me greater pain than what is necessary. I wanted him to treat me in the best professional manner. Every client who comes to you would want that from out of you. Remember that, and you will become a better lawyer. Let me give you this. In fact, in New York, state practice, I was telling you about the concise, precise manner in which plaint has to be written. New York state practice specifies that every pleading shall consist of plain, PLAIN, plain and concise statement in consecutive numbered paragraphs, and each paragraph shall contain single allegation. That's why I said different ideas in different paragraphs. Concise, plain, precise, in the shortest sentences possible. Even the federal rules of practice in US of Civil Procedure 8A specifies that every averment of pleading shall be simple, concise, and direct. There lies the beauty. That is what CP code also says. Coming to the art of drafting. We all, at some point of time, painted or drawn some sketches, at least during our primary and middle school or the high school. Before you paint, you always envision the painting that you will eventually produce. Why do you do that? Because if you don't have a vision, if you do not think as to what final result should be, you will not be able to paint what you want to paint. Supposing you want to paint a caricature or say a river flowing, you must think how the river will flow before you take the paint and the brush and put it on canvas. Similarly, when you draft a plaint or a petition, you must mentally prepare as to in what manner, in what direction you should go. That is why first thing a lawyer must do is, I'm now meandering, pardon me because time is too short. When you meet a client, he wants you to draft something. He is the master of facts. Have the patience to sit with him, listen to everything that he says. Many a times, he will not know that certain of the facts which exist in his memory are not relevant. You may have to prod his memory. If you know what the law is, if you know in what direction the plaint that you want to draft or the petition that you want to draft should be, in what direction it should go, you will be able to prod the client and elicit information. And that information will assist you in preparing a better draft of a plaint or a petition. That is why I said, before you paint on a canvas, think, what is it that you want to paint? What is the ultimate result that you want? Now, coming back to the plaint. First, you have the heading. You have the addresses. You have the factual matrix. You must also mention the cause of action. Because if there is no cause of action for a suit, the suit is liable to be dismissed. Ultimately, you will have to set out the prayer. When you draft, one of the common things that I have noticed is every second sentence in the plaint, he will say, the plaintiff submits that, plaintiff submits that. You have stated already in the beginning, plaint under orders, section 26, order 7, rule 1, the plaintiff above named submits as under, then you start the facts. When you do that, every sentence, you need not start with the sentence, with the words, the plaintiff submits that and proceed. I found every second sentence, lawyers drafting and saying, plaintiff submits that he is the owner of the property, plaintiff submits that the neighbor has tried to interfere, plaintiff submits that he purchased it from his from XYZ under register CLD dated so and so, plaintiff submits that. If you remove this gibberish, I think at least you will save 1 page in a plaint of 10 pages. In an affidavit, every sentence starts with, I say that, I say that. Avoid it if it is possible. Let it be direct sentences, short, simple. Then, coming to prayer, let the prayer be precise. Ultimately, in the end, always put a general prayer, seeking relief, such other and further reliefs as are just. You may ask me, what is this? Why should we ask for it? Let me give you one judgment of the Honorable Supreme Court of India, where the Supreme Court granted relief only on the ground that there was this general prayer that he sought for such other and further reliefs. One of the argument canvas was that there was no prayer for it. Supreme Court granted relief, stating that, yes, there is this general prayer. AR 1962 Supreme Court, 1161, paragraph 4 and 11. AR 1962 Supreme Court, 1161. Appropriate relief may be granted due to changed circumstances. And because, this is what the Supreme Court said, because of the prayer for any other relief in the petition. Maybe some judge may not agree with this proposition because 2013 there's a judgment contrary to this, not noticing the 62 Supreme Court. But if the judge is benevolent, if the judge is a liberal, he will grant you relief on the basis of this. We all know that the normal rule is if there is no prayer, you cannot grant a relief. After all, Supreme Court has held that court cannot grant relief not prayed for. 2008, volume 17 SCC 491, 1991, 1 SCC 441, 2004, 13 SCC 528, any number. In fact, I gave you the judgment of Supreme Court in 62 Supreme Court's 1161. There's a contra judgment in 2013, but earlier to that, 1993, Supplement 3 SCC 129, a prayer was not sought for, a declared relief was not sought for. Supreme Court said you can't get the relief because you have not sought for this declaratory relief, and relief can't be given because you have sought for other reliefs. But 62 Supreme Court says, well, you can get a relief on the ground that you have sought for other reliefs. Because ultimately, courts have also held that procedure is a handmaid of justice, and procedure is meant to subserve justice. Therefore, a liberal judge will always grant you relief, even if the relief is not sought for in the manner that he would have wanted you to, if there's a general prayer saying, grant such other and further relief. Always put it, both in the main relief as well as in the interim applications. You may have asked for attachment before judgment in an interlocutory application. Judge may feel that you would be entitled to an injunction. And if you put that sentence at the end and grant an attachment before judgment and grant such other and further reliefs, if he feels that, well, you are entitled to an injunction, may not be for attachment before judgment because that is far more arduous and greater circumspection is needed, he may grant you the injunction. So the prayer, remember this. Then, when you come to the writ petitions, appeals, I was on the appeals. When you come to appeals, same thing. Always prepare your appeal memorandum like you would prepare a plaint. Concise, precise, your best foot forward, always. Your best foot first. That is when the judge, after all, many judges read. If you have a lengthy petition of, say, 20 pages, at least they'll read in at least about 4 or 5 pages. Initial grounds they will read. If you are able to show that you have a good case in the beginning, then there's every possibility of the judge, even before you get up, to say, all right, I will issue notice. So these are the techniques that you must adopt in your daily practice. Then, in a writ petition, today we have reached a stage where COVID has taken hold. It's all now VC, always video conference. You are not able to give judgments across the bar. So what do? In the writ petition or in the appeal, set out the judgment. So-and-so versus so-and-so in, say, 2010 Supreme Court, 5 Supreme Court cases, 435, paragraph 16, they have stated so. Cull out a small portion of it, which is in your favor. Set out some of these judgments. In a VC hearing, that will help you enormously because you are not able to give the judgments across the bar. If you set out those judgments, 2 things follow. 1, you may not remember it when the matter comes up for final hearing. When it is there, it becomes easy for you. It will prod your memory. Becomes easy for you to take out the judgments and maybe, do further research from there. This earlier judgments which you have put becomes the foundation and you can leapfrog from there. These are the techniques. Always evolve it. Always adopt it. Then election petition. It's a different ball game altogether. In election petition, all material particulars must be set out. And if you do not set out material particulars and full particulars, the petition itself is liable to be dismissed at the initial stage. So these are the differences. I think I have taken nearly an hour. Now, let me, I think about 45 minutes. Let me, give you some more judgments. Now, in a written statement, one of the things that invariably, lawyers do is they don't take paragraph by paragraph and deny the statement or counter the statement made in the plaint. That's not a good habit. Take each paragraph, does not matter. One shouldn't, lassitude should not take over your professional attitude. You must take paragraph by paragraph and counter it. Whether it be a writ petition, whether it be a counter to an application filed under order in respect of an interlocutory application or in a written statement. In fact, Supreme Court in 1993, 4 SCC 6 has held that when there is no denial in the written statement, allegation is deemed to be admitted. And in 2013, Volume 2 SCC 609, Supreme Court has held denial in written statement has to be specific, as general denial is not sufficient. When there is no denial of signature in a written statement, High Court committed an error in holding that the handwriting expert should have been examined. See how the courts have looked into things. You have to specifically deny, and general denial is not sufficient, is what they have said. Then, admission in pleading. See, when you draft a plaint, be wary of admissions. Many a times, I have succeeded in appeals based on the admissions made in the plaint itself. 1974, 1 SCC 242, paragraph 27. 1974, 1 SCC 242, paragraph 27, Supreme Court has held admission in pleading or judicial admissions stand on a higher footing than admission in evidence. And they have said further, judicial admissions are fully binding on a party and constitutes waiver of proof. So be wary when you draft a plaint. That's why I said think. Many a times we make mistake. In fact, not realizing that we are admitting certain things in the plaint we may admit, even though that may be contrary to the fact. I am not saying be untruthful. Never do that. Lack of candor should never be there. You must be upright, honest. That's when you'll be appreciated. But then, when you put across things, you must weigh and put it across. Supreme Court in 2005, 1 SCC 324 is a lengthy judgment at paragraph 218. 2005, 11 SCC 324, para 218. They've said judicial admissions can be made the foundation of the rights of the parties. And in 67 Supreme Court, AR 1967 Supreme Court 341, Supreme Court has held admission in plaint can be used against a party in other suits as admissions, not just in this suit. It can be used in other suits where you are a party. Order 6, Rule 5, 3 and 5. Allegations of fraud must be clearly pleaded and proved by clear, cogent evidence. There must be a plea as far as fraud, misrepresentation, breach of trust. You must plead clearly, and all material particulars must be indicated. If you don't do that, then court will not permit evidence to be let in. Also bear in mind, no amount of evidence will be permitted if there is no pleading. Now, in my plaint that my colleague prepared, he did not allege, he did not ever that as a result of this building without a setback, his rights are adversely affected. He did not plead it. If he leads evidence, a lawyer, astute lawyer will say, please look at 2008, Volume 8 SCC 932. Also in 2011, 8 SCC 613, paragraph 33. Without pleading, no amount of evidence can be looked into. Therefore, pleading, the plaint averments, the petition averments become absolutely essential. Civil suits, Supreme Court in 2019, 11 SCC 800, Supreme Court has held civil suits are decided on the basis of pleadings and issues framed, and parties cannot be permitted to travel beyond the pleadings. So that is the reason why I said gather as much facts as possible from the client, put everything, but in a precise, concise manner, not elaborately running into 100 pages. That you won't have the time. When you start cross-examination, you won't have the time to look into 100 pages. When you start arguments, you will not have the time, because by the time the matter comes up for final hearing, you will have become a senior. Recently, in 2020, Volume 1 SCC 729, Supreme Court has held, in the absence of pleading, no amount of evidence will help the party.